Today we're going to talk about we'll start with section 118, which is relative to restricting no-knock warrants. And there are 4 subsections in this, and let's go through them all 4 of them briefly. So no-knock warrants, subsection A. This section shall be cited as the Breonna Taylor Justice Act. And for those who don't remember, Breonna Taylor, it was a little less than 2 years ago, beginning of 2020 in Louisville, Kentucky, when Breonna Taylor and her boyfriend were at home a little after midnight on March 13th, and they heard somebody pounding at the door, and somebody was trying to get through their door. And so they went out from the bedroom into the hallway. When they didn't know who it was, fired a shot through the door to ward off the intruder, and it turned out to be the police, who fired some 332 bullets back through into her apartment, striking Breonna Taylor 6 times. And her boyfriend, as she lay there dying on the hallway floor, called 911, asking for help, asking for the police to come and help them to protect them from whoever was breaking down their door, only to find out that it was the police who had been serving a no-knock warrant, despite the fact that the subject of the warrant, an ex-boyfriend of Breonna's, was actually in their custody across town at that time. And this death of an innocent woman in her own home in the middle of the night, it shocked the nation. And her U.S. Senator Rand Paul introduced a piece of legislation prohibiting no-knock warrants. And unfortunately, what he introduced was more of a soundbite to say that nobody can use a no-knock warrant, because there's a very thin line between knocking on the door and but between breaking down the door and announcing that you're a police officer, and then breaking down the door. And so section 118 seeks to address this by restricting not just the use of no-knock warrants, but the actual smashing in of a door for the police to break in. Now, a lot of this comes from a 2003 Supreme Court decision, the United States versus Banks. And they ruled that 15 to 20 seconds after the police announced that they were there with a search warrant, it was okay to smash the door in. Now, in this case, they were serving a search warrant on a suspected drug dealer who was in the shower when they came knocking at his door in the afternoon. And the Supreme Court said, quote, on the record here, what matters is the opportunity to get rid of cocaine, which a prudent dealer will keep near a commode or kitchen sink. The significant circumstances include the arrival of the police during the day, when anyone probably would have been up and around, and the sufficiency of 15 to 20 seconds to get to the bathroom or the kitchen and start flushing cocaine down the drain. That they ruled were exigent circumstances, because the pusher may be near the point of getting his drugs beyond reach. And so that threat of potential destruction of evidence gave the police made it reasonable for the police to break down the door. They said, quote, 15 to 20 seconds does not seem an unrealistic guess about the time someone would need to get in a position to rid his quarters of cocaine. Of course, once the exigency had matured, the officers were not bound to learn anything more or wait any longer before going in, even though their entry entailed some harm to the building. 15 to 20 seconds. It's certainly possible that someone can come to the door in 15, 20 seconds. As somebody who's campaigned for office and knocked on lots and lots of doors in my community, it's possible for someone to get there in 15 to 20 seconds. But, usually when I knock on doors, you got about 30 seconds before I'll knock a second time. And then another good 30 seconds or so before I'll, leave a note and head on to the next house. Smashing down someone's door after 15, 20 seconds seems pretty extreme. Now, no-knock warrants are used tens of thousands of times every year in this country. The majority of them are used in drug cases. The majority of them are served on people of color. They're issued for a variety of reasons. Confidential informants, people who might be facing other charges, other criminal charges, might come forward and say, hey, I know somebody that you should go after. If you'll reduce my time or the charges against me, I'll give you evidence. Confidential informants have done this in many occasions. Police end up going to the wrong address. They're looking for the wrong person, as they were in Breonna Taylor's case, somebody they already had in custody. This happens far, far too many times. Now, it's important to qualify that the Blueprint for a Better America, in our mission to establish justice, it ends the federal drug war. And so on the federal level, there will be no more drug cases. That'll be up to states to set their own policies. So a lot of these will go away on the federal level, and they will be more targeted towards real exigent circumstances and not the hypothetical destruction of cocaine within 15 to 20 seconds. It's also important to look at how, what is someone's reaction when someone comes bursting through their door with no warning or with very little warning. In Breonna Taylor's case, the police clearly had not identified themselves to the occupants, which is why her boyfriend defended his home, his castle, by firing back. And as we've seen the castle doctrine sort of expand around the country, these are the origins of the Fourth Amendment protections in the Constitution. The idea that a person should be secure in their home from unreasonable searches and seizures. And the idea of no-knock warrants really goes in the face of that. So subsection B of this part of the bill contains a prohibition on forcibly entering an occupied dwelling. If somebody's there, then you can't force your way in unless it is daytime. Daytime is defined under Rule 41A2B of the Federal Rules of Criminal Procedure as being between 6 a.m. and 10 p.m. If you need to force your way in, do it. Again, breaking down people's doors in the middle of the night is just a recipe for confusion, for people getting hurt. This would restrict it to daytime hours. During daytime hours, federal law enforcement officers would be prohibited from forcing their way into an occupied dwelling unless they had a no-knock warrant, or the occupant refuses admittance to the officer pursuant to Section 3109 of Title 18 of the United States Code, after having provided notice of their authority and purpose. And so this goes back to the idea of being able to yell police and then a few seconds later smash in someone's door. Technically not a no-knock warrant if you announced yourself and knock before smashing in the door. But subsection C of this part of the legislation would create a rebuttable presumption that before officers were entitled to claim that they had been refused admittance, that they needed to repeatedly knock and give people inside time to answer the door. This bill creates a rebuttable presumption that between the hours of 8 a.m. and 9 p.m., 3 minutes, if you're knocking over a 3-minute period of time and they refuse to answer the door, that they are refusing admittance. Or during other times of day, a 5 minutes of knocking on the door. This gives people time to get out of the shower. In the case, United States versus Banks, he was in the shower when the police showed up at his door. Especially, again, it's certainly possible to answer a door within 15, 20 seconds, but it's also just as possible that you're not ready to answer a door within 15, 20 seconds, that you need a couple of minutes to finish eating a brisket sandwich, to put some pants on, to, wake up, get out of the shower, do a variety of things. And so before the police come smashing through the door, this bill establishes that waiting 3 minutes during normal hours or 5 minutes outside of that there's a rebuttable presumption that they have been refused entry. Rebuttable presumption is one of my favorite in the law. This would be like if I caught my teenager sneaking into my house at 2 o'clock in the morning. There's a rebuttable presumption that they've been up to no good. Now, it could be wrong. Certainly, they can rebut that and say, hey, just had a craving for midnight for late night Taco Bell, and that was it. And there's nothing nefarious going on here. But rebuttable presumption says the burden of proof is on you to prove otherwise. And in these scenarios, if the police have knocked on the door for 3 minutes or longer, then it's a rebuttable presumption that they've been refused entry. Until they've been refused entry, they shouldn't be smashing people's doors in. Subsection D of this provision is the part that applies to states, as we've seen in other sections of the George Floyd Justice Act. This is federal legislation, and so we incentivize states to adopt similar protections. And so once again, beginning the 2025 fiscal year, states would be restricted from receiving funds under the COPS grant program unless they had a law that prohibits the issue of no-knock warrant in drug cases, and also restricts the uses of no-knock warrants to daytime hours. Drug cases especially, there's many members of law enforcement who've also called for an end to this practice. Dozens of people, including police officers, get shot when they burst into people's homes. And it is an unnecessary escalation, and it can be addressed through this legislation. The Justice Department last September announced that they would limit the use of no-knock entries in connection with the in connection with the execution of warrants in a couple of ways. And so this would apply to the FBI and everybody under the Department of Justice. And so it limits them so that agents could only seek judicial authorization for a no-knock entry if they had reasonable grounds to believe that knocking would create an imminent threat of physical violence to the agent and or another person. So the idea that maybe someone could possibly destroy evidence unless you bash their door in would no longer be justification for a no-knock entry, except in exceptional circumstances such as a national security matter, where an agent believed that the evidence was so significant and the risk of its destruction so pronounced that a no-knock entry was warranted. They would first have to get permission from the Attorney General before asking for a no-knock warrant. And then the second part of this new policy for federal law enforcement officers would be that if the agent didn't anticipate a need for a no-knock warrant and get such a warrant, they could only for exigent circumstances could they then serve a warrant in a no-knock manner. And so these are good restrictions, a good update to the policy that focus on harm reduction as opposed to potential what if of destruction of evidence in a way that just escalates the whole situation. So these are good policies, but as we've talked about for other parts of this legislative package, policy can be changed. The next president of the United States could direct the Department of Justice to change this policy. And so the proper solution is to fix it by writing it into the law and making it very clear that the Supreme Court can interpret the existing law to say 15 to 20 seconds is not an unrealistic amount of time. And instead, Congress can clarify that that is an unrealistic amount of time before breaking someone's door down. And a few minutes is more appropriate. So, like many things, this is something that Congress can fix. They have just refused to act. And so we can do it in 2022 with this legislative package. Mr. Chair, I guess that concludes my testimony for Section 118, and I'd be happy to answer any questions.
Thank you. Yes, we do have a question from Tony in California. Won't ending the use of no-knock warrants put police at risk?
Thank you for the question. I mean, there's a certain amount of risk in everything that we do. And so is it possible that if the police come knocking on a door with a search warrant, that the person inside decides to, make their last stand as opposed to, opening the door? It's not impossible. But we need to look at the overall picture. Like, what is probable? How do these things usually shake out? I saw a video on Twitter the other day of the police serving a no-knock warrant because an IP address from that location had been used to make threats against the local police department. And so, they smashed in the door, burst into the house, little girl watching TV, pointing their guns at her, zip tying her hands behind her back, when in fact, the house had an open Wi-Fi network. The police were pretty sure it wasn't them, but they just went ahead and burst in anyway. And what is the harm that causes? And this happens far too frequently in poor communities where the police come bursting in, pointing their guns at children. What is the harm that's caused by those actions? And that has to be balanced out with the larger, as part of our larger goal, our larger duty to establish justice. In that case, once the police figured out that they had wasn't the right house, they went and they called the guy who they thought had done it, and he came down to the police station and turned himself in. There was really no need for a no-knock warrant for the violent escalation in this case. I guess one possible reason for these sorts of tactics is, as we talked about, the use of military surplus being donated to police departments. There is a requirement that the police use the equipment in the year after getting them. And so, as a way to justify some of the military surplus that they get now, they need to put it to use. So Tony asked a good question. Isn't it possible that could put the police at risk? And the answer is, in a country of 330 million people, there is a non-zero chance that will happen. But in the grand scheme of things, in the way that tens of thousands of these are being used right now, there's far more harm being done with the current policy.